Illinois House Bill 3653, the so-called Illinois Criminal Justice Reform Bill. Well, at the time that we made this video, both House and Senate, the Illinois Congress, have passed this bill, and they've sent it off to Governor Pritzker's desk to be signed, and he's expressed support for it. So, my name is Attorney Bradley Fuller. I'm a senior associate here at CTM Legal Group in Chicago, and I want to give you a basic overview of this bill, what it is, and some of the things that it doesn't do, because there's a lot of misinformation going around about this bill. Things like it's a defund the police bill. There's nothing in all 750 pages about defunding the police. There's an idea that it's somehow a racialized bill. Nowhere in the bill does it talk about white or black or racism. It just applies to everyone equally. Also, that as soon as it's signed by the governor, it's going to take effect. That isn't true. It's phased in over 4 years. So let's take a look at the most relevant portion of this bill to me, which is the court reforms. Now, this bill, as I said, is very large, and it can be broken down into several different sections. And let's begin with what I'll refer to as court reforms. Now, this is the most relevant to me as a criminal defense attorney and to my clients. And the first thing this bill is going to do is end monetary bail. So if someone's arrested, then they would have to post a certain amount of money in order to be released before their trial. Now, this is going to take effect on January 1st of 2023, and at that time there will be no monetary bail. Now, monetary bail really doesn't make any sense. So why should someone be charged with a serious crime like rape, for example? There's a ton of evidence against this person, but they just happen to have access to tens, hundreds of thousands of dollars, maybe millions of dollars, and they get to post bail and they walk and then draw out litigation for years while they're walking around not in jail. On the other hand, you could have someone where there's not a lot of evidence against them. Maybe they're even innocent, and it's a very low-level nonviolent offense, but they sit in jail, and we as taxpayers pay for them to sit in jail just because they're poor and don't have money to post bail. So monetary bail doesn't really make any sense. Now, some misinformation about ending monetary bail is, oh, well, then everyone who just commits crimes is going to go free. That's absolutely untrue. What there will be instead of monetary bail will be a detention hearing. So the state will file a petition for detention. They'll bring it in front of a judge. Now, as the criminal defendant, you will have an opportunity to meet with a criminal defense attorney before the detention hearing. That's an important right that's in the bill. And the judge will hear evidence about whether or not you're a danger to the community, whether or not you're an actual flight risk. And the judge can decide to detain you. So that's a very important reform that's contained in this new House bill. Also, they're no longer going to consider a simple failure to appear in the past necessarily against you at bond or detention hearings. Think about now during the pandemic, people are not showing up to court because there's a global pandemic on and there might be a failure to appear in your background. So you can see why it's important that this bill takes that into account and says, judges, no, just because there's a failure to appear in someone's background, it doesn't mean that they're necessarily a flight risk. So that's a nice criminal justice reform as well. Also, this bill allows police officers to make arrests and release people and give them a 21-day summons. So instead of having to arrest them, book them, hold them in jail, we pay for it as taxpayers, and you have to take them in front of a judge, and they have what's called a Gerstein hearing and a bond hearing. It all takes place over a couple of days. Well, in low-level offenses where it is obvious that the individual does not pose any risk to the community, officers now can just issue a summons, say come back to court within 21 days, just like they would when they were writing a traffic ticket or something. So that is an excellent reform as well. Also, this bill is going to end the suspension of driving privileges for people who have failed to pay fines and costs associated with traffic offenses and like abandoned vehicle fees. So that's an excellent thing. If someone unfortunately has to abandon a vehicle, it gets towed, there's impound fees, and they can't pay it, but they want to go to work, they want to drive their children to school, they want to take themselves to their medical appointments. We don't take away their license and make it harder for them to actually pay the fines that they owe. So you still have to pay those fines, but they're not going to take away your driver's license just because you haven't been able to pay in the past. So that's an excellent reform as well. Also, it expands eligibility into mental health courts and veterans courts. Those are proven courts that absolutely work. We have the data, we know they work, and now we're going to open eligibility to those courts for more people, so that's an excellent thing. Also expands good time credits against IDOC sentences. So if someone is able to obtain their associate's degree while they're in custody, if someone's able to participate in and complete self-improvement programs, well, we incentivize them to do that. We make them more productive citizens when they're out of custody, and we have to incentivize that by we could take some time off of the sentence that they'll ultimately serve. So that's another excellent reform. There's a change to the home detention sentencing credit. So now if you're detained at home for more than 12 hours per day, that's going to be counted as a day of credit that you'll get on your sentence. And there's some changes to the electronic monitoring violations program. Essentially, in some cases, it'll have to be 48 hours worth of a violation, not just 1 second or 1 minute that could violate a person. It eliminates in some cases what we used to call parole, which is now mandatory supervised release for, again, low-level offenses, class 3 and 4 felonies. And when the prisoner review board sees that this person, we're just wasting taxpayer dollars, we're wasting resources on having them report to a parole officer, this person doesn't need to be on parole, so we can eliminate parole, the need for parole, for low-level class 3 and 4 offenders. Now, even for those offenders, if the prisoner review board thinks, no, this person does need to report, then we can still institute up to 12 months of MSR. But in many cases, it's a cost-saving benefit, and it's better for the lives of the individuals in our community who are released from custody, low-level offenders. It clarifies the felony murder rule, which is very important in the criminal court context, and I'm going to read it to you. It now says, he or she, acting alone or with one or more participants, commits or attempts to commit a forcible felony other than second-degree murder, and in the course or in the furtherance of such crime or flight therefrom, he or she or another participant causes the death of a person. So that actually expands and helps to clarify the felony murder rules. So this isn't just a bill that is benefiting in every way criminal defendants. In fact, in some ways, this is making it easier for individuals to be prosecuted in cases where someone has clearly died and they should be prosecuted. So this criminal justice reform bill helps prosecutors and law enforcement in several ways too. It modernizes the Illinois 3 strikes rule. That's the habitual criminal rule where if you have 3 serious crimes, you spend the rest of your life in prison. Now, if you have committed a crime before the age of 21, a serious crime, that will not count against the 3 strikes rule. You have to be at least 21. And that makes a lot of sense given what we know about juvenile behavior. It does allow the court, in very limited circumstances, to deviate away from mandatory minimum sentences. And this is what it does. It allows, in cases of retail theft, in cases of simple drug possession, not selling drugs, and driving on a revoked license due to unpaid financial obligations. So in those 3 circumstances, if the court finds that the defendant does not pose a risk to the safety of our communities and the interest of justice require those mandatory minimums that used to put people in prison. We used to mandatory send people to prison for simply because they couldn't pay their fines and they continued to drive because they had to go to work or take their kids to school, and they would get pulled over, and to get enough of those tickets, it used to be mandated that we send those people to prison. So if anyone tells you that this bill gets rid of mandatory minimum sentencing, that isn't true at all. It's only in very, very specific, limited circumstances that make perfect sense. Retail theft, just drug use, not selling drugs, and driving on a revoked license because you couldn't pay fines. If the judge finds you're a good person, not a risk, and the interests of justice demand it, then the judge can deviate from those mandatory minimums. Also important to know that if you are arrested, you will get 3 phone calls and access to your phone. You will be able to make a phone call up to 3 people, and you'll be able to look into your phone. If the police have taken it off of your property, they've put it in the lockup, then you can say, no, I want to actually look. I need to know those numbers so I can actually reach out to somebody and let them know where I am. So that's a really important and just common sense reform, that we allow people to make 3 phone calls if they're now arrested, and we allow them access to their phone so they actually have the numbers that they can call. You no longer can be charged with resisting arrest if it's an illegal arrest. It used to be that if you resisted an illegal arrest, you were still guilty of resisting. Now the police will have to establish a predicate offense, a valid predicate offense, to bust on anyone for resisting arrest, which I think is another very common sense reform. So those are what I would call the court reforms. There's still a ton left in this bill that is related to prisoner and detainee rights, also police accountability and decertification, and we'll get to all of those sections in upcoming videos. Thank you. Again, my name is Attorney Bradley Fuller. I am a senior associate with CTM Legal Group here in Chicago. We occupy the top floor of the world-famous Chicago Temple Building, right across from the Daily Center and City Hall. Please contact us at 312-818-6700. Again, that's CTM Legal Group, and our number is 312-818-6700 for all your legal needs.